Hello, and welcome to another one of our short teaching sessions, which looks at some of the technical issues around agricultural tenancies and how we advise members about them. Now, my name is George Dunn. I am the Chief Executive of the Tenant Farmers Association, and I'm going to be hosting this session today. So, as I said, this forms part of a series of teach-ins which try to shine a bit of a spotlight on the topical issues being faced by the tenanted sector of agriculture. And it's part of our growing library, which you can access from YouTube. And it also features webinars and our weekly news updates. So today, we're going to be hearing from Sarah Sumner, who is an expert rural surveyor here at the TFA. And she's going to be talking to us about what happens when a landlord of an Agricultural Holdings Act tenancy seeks to take land back for development through what we call Case B notices to quit. And you'll hear a bit about that in a moment. But before I introduce you to Sarah, I just want to say that we're delighted to be supported by Oxbury Bank, who are sponsoring the entirety of our 2023 virtual program of events and teaching sessions. And for those of you who maybe don't know Oxbury was formed in 2021. It was founded by bankers, farmers, and technologists. And they are the UK's only bank which is 100% dedicated to serving farmers, food producers, and the rural economy. So it's great that they are supporting us in our virtual program this year. So to today's content, we're recording this in the summer of 2023. So everything we cover today is correct at the time of recording. So if you want advice for your individual situation, we certainly recommend that you call the TFA head office and ask to speak to one of our team of advisors like Sarah. So without further ado, I shall introduce you to Sarah, who, as I've said, is one of the TFA's specialist rural surveyor advisors. And she will take you through some of the key points to consider when dealing with a landlord attempting to resume land for development from an Agricultural Holdings Act 1986 tenancy. So welcome to Sarah, and the floor is yours.
Good morning, George. So today, as you say, we're talking about Case B notices to quit. So firstly, what is a Case B notice to quit? It's what we would look at as a special notice to quit, because it enables the landlord to take back land without getting tribunal consent. Most notices to quit, general notices to quit, can be counter noticed by a tenant and brought in front of a tribunal, and are generally very hard for a landlord to enact. But a Case B notice is generally incontestable. There are some very specific reasons why it might not be, when it may be contested. And that's if it's been invalidly served, or that the landlord has not satisfied all the requirements. So they may not have potentially got planning permission for the correct area that the notice is served on. It may be used on a part of the holding if the tenancy allows for it to be used for part of the holding, or for the full holding. And the landlord must establish a present intention to develop. So where they are going for planning permission to change the use of the land to non-agricultural, they must actually have an intention to actually carry out what they have put planning permission in for, and that land, the agricultural use of the land, will be extinguished. So what actions can a tenant take? You can have the next slide, please. Thank you. So whenever we get a call about a tenant concerned about a landlord taking back land for a non-agricultural use, the very first thing we would advise, if at all possible, is for the tenant to talk to their landlord. This isn't always possible. Things sometimes happen by surprise. or there might be already a deteriorated relationship between the landlord and tenant, but things generally go a little bit smoother if you can have a discussion with your landlord and work out exactly what's going on, what their intention is, and maybe a little bit more in the loop. If you've gone through that stage, or that stage isn't open to you, you can object to planning applications. You could also potentially appeal the notice if there are grounds, which we mentioned earlier. And after all that, if the planning application has gone through, you've had a notice to serve, notice to quit served upon you, there is a statutory route to claiming compensation, which is generally written as 5 or 6 times the passing rent. And it's written like that because there's a specific type of notice that needs to be served in order to get the slightly higher statutory compensation value. So that is a very, very quick run through in brief about case B. Obviously, it is a complex area. So there will be many differing situations depending on your specific tenancy and farm and whatever the case B is.
Thanks, Sarah. That's a really good overview of that particular issue. And clearly it's a very difficult time for individuals when they get wind of the fact that the landlord wants to take land back for development opportunity. So I'm going to ask just a few questions on case B, notices to quit, and when landlords take land back for development. So there's been a lot of talk recently about landlords wanting to take land back for tree planting and for rewilding schemes. Will such activity fall within the auspices of a case B, notice to quit? And if not, how might that play out?
Okay. Yes, it has been quite a popular subject coming into the office of late. For both tree planting or rewilding, as planning permission isn't needed to change the use for that, case B wouldn't actually be applicable in those situations, as it can only be used where the land under the notice is subject to a change of use, where planning permission is actually required. So in those situations, we would consider that a landlord would need to use a standard notice to quit, general notice to quit, which if the tenant counter notices on very tight, strict timescales for counter noticing, but if they counter notice, the application or the notice to quit can be called in front of a tribunal, and the tribunal would then be able to consent to the operation of it and test whether the landlord's request is fair and reasonable. These are notoriously incredibly hard and tight for a landlord to get, and in these situations, would be rare or very unlikely that a tribunal would consent to it.
Okay, so there is some hope then when we have landlords wanting to take land back from tree planting in terms of it not being an incontestable notice. That's really helpful to know. So the compensation when there is a case B, notice to quit, is 5 or 6 times the rent passing for the land and buildings that are being taken. Now, in many cases, that's obviously not going to be sufficient compensation for tenants losing land or buildings. Can a tenant object to an application for planning consent from the landlord on the grounds of the impact on their business?
Yes, they can. I think one of action that a tenant should always consider, unless they've had a very good discussion, sensible discussion with their landlord beforehand, is to object to a planning application. There is some quite good case law that we often refer to, which was a case brought against the Vale of Glamorgan District Council with a tenant involved called Mr. Adams, where it was proven, I believe it was an appeal, so it was proven that the grant of the planning permission would be detrimental to the tenant. obviously each situation is different, but that's a very useful case to actually put to planners as part of the application, as it is an additional reason for objection other than standard planning objection routes. So if the planning application is turned down, obviously the landlord couldn't serve the case B to notice to quit. So I suppose in our experience, we think if a tenant starts talking about objecting to planning, or if the landlord is concerned that it might upset the planning application, they quite often start talking to the tenants and being a bit more lenient, a bit more helpful in terms of offering higher than statutory compensation for cooperation or their support of the planning application, which would then obviously be a little bit more attractive than the statutory 5 or 6 times the passing rent.
Okay, and obviously we've been talking about case B notices to quit within the context of Agricultural Holdings Act tenancies. But what about those tenancies regulated by the Agricultural Tenancies Act, the Farm Business Tenancies? Is there a similar statutory regime for landlords to gain land back for alternative uses, or is it all down to the individual contracts in those cases?
Well, like with so many things under the Agricultural Tenancies Act 1995, it will be down to the contractual terms. They can very widely vary from tenancy to tenancy. So it's crucial to look into the terms of the tenancy, look at the specific clauses, as they will help to determine what rights the landlord has to take back land, what rights of compensation there are, timings, maybe restrictions that they can take a certain percentage of the land back or a certain acreage, maybe over 12 months, or it may be completely open-ended, or there may be absolutely no right for the landlord to take back land. So it very much comes down to tenancy. So we would always request to see individual tenancies to know how to advise members.
Great, Sarah. Thanks so much for your time. So we'll let you go in a minute back to advising members, which we know you do on a day-to-day basis. Now, those of you who are watching this and or listening to this, and you've got more questions around your individual position, you can become a member of the TFA, and membership is good value for money. It's only £249 per year. And this will give you dedicated access to advice, information, and support from advisors and rural surveyors like Sarah in our team. And you can find out more about the TFA at the end of this teaching by clicking the link to a short ability to apply for the membership of the TFA. So I hope you found this teaching helpful. It's part of a library, as I said, of other material that's available for you. You can access from our YouTube channel or from our website. Don't forget to like and subscribe to the channel so that you don't miss out on any content as we post it and make it available for you. Thanks again to Oxbury for sponsoring our virtual program this year of teach-ins and webinars. Now, our webinars are taking a bit of a summer break at the moment, but we will be back in September when we'll be talking about the 2023 Sustainable Farming Incentive Rollout for farmers in England. This webinar will feature Janet Hughes, who's the Programme Director in DEFRA. Janet has been a regular attender at our webinars in the past, so it'll be good to have her back. But we've also got joining her Maria Hardman, who has recently been appointed as the new Rural Payments Agency Customer Director. And details of how to register for that webinar is on the TFA website, www.tfa.org.uk. So it only remains for me to say huge thanks to Sarah for being with us today for this teaching, and we look forward to seeing you again soon. All the very best.